For item number 1 for delivery of orders. Sorry. Item number 1, WPC 14835 of 2025.
The description stands report of but in the circumstances, there shall be no other financial costs.
For judgment item number 2, WPC 37383 of 2021.
Based upon the discrepancies, we feel that the imposition of the department for a period of 5 years too harsh and offends the doctrine of proportionality. Nearly 4-year period has elapsed when the matter is pending before this court, and therefore we feel it would cause a greater hardship if the order of blacklisting is allowed to operate a full period of 5 years. The petitioner has already been deprived to participate in any tender from the date of the order of blacklisting until the date of this judgment, which in our opinion has percolated a message in the petitioner a sense of responsibility and to maintain orderly behavior while dealing with the government officials. On ex debito justity, we set aside the remaining period of the blacklisting, taking into account that the said order of blacklisting shall be operative till the date of this judgment. On the doctrine of proportionality, we have.
Item number 3, WF 489 of 2025.
The writ appeal being devoid of merit is dismissed as a consequence thereof. The judgment of Lord single judge entered in the writ fiction stands upheld, but in the circumstances without any order as to cause.
Item number 4, WPC 13821 of 2025.
In the result, therefore, without expressing any opinion concerning the merit of the matter, this restriction is disposed of with the aforesaid observation and direction, but in circumstances there shall be no other cause.
Pass on the memos.
It is a debarment matter. It was heard, reserved, and again it is released. Now it is already pleadings are all
Released, heard, released by whom?
by your lordship's predecessor. I mean, it was actually judgment was reserved.
Oh,
And
you become encouraged by judgment which we delivered now.
No, Lord. And that is anyway will come the benefit in my way. I request your lordships to kindly visit.
Please pass on the memo. We'll definitely hear all the matters. Pass on the memo.
Item 19 and 20 may be perfect. Item 19.
Give the memo of withdrawal. Who is for the other side? 19 and 20? Any interim order or there is no interim order? 19 and 20?
1941.
Last order is there, 15/5. What are you talking about, sir? There is an interim order. So? So, do you object or do you not object?
Just simply after we can.
It is not applicable because the council for the money, the withdrawal, drop, entry order. Stand. Yes, go.
Item number 1,
Recording. You don't know. Yes.
Yesterday, your lordship has jarred that this has come to other instruction.
What is this? Can you refresh our memory?
Yes, sir. The main contention of the petitioner is that the auction notice which is under challenge, the transfer of that cannot be done because it is the property of the DT.
Oh,
Jagannath.
Jagannath,
Yes, sir.
the act, yes. What instruction?
Documents if I may hand over.
State government's permission. The act says that with the previous version of the. The permission has been granted?
Still permission has been granted.
How? Without changing or taking the property from the pool of Lord Jagannath's asset? How can you?
My lord, if I may refer to the minutes of the document.
Where is that? You just showed me that law.
Section 16.
Can you?
Yes, my lord, I am handing over now. Here's one.
Section?
Section 16, subsection 2.
No, actually, sorry. Yes.
Yes, my lord. If I may refer to the first letter, which is 10th September 2024.
10th September 2024, yes.
In the subject, is the paragraph inviting reference to subject cited above and directed to include herewith the minute of the meeting. So, on formulation of guidelines for management of minor and middle sources of the Jagannath temple administration for the kind information and necessary action. Third page, my lord. Serial number 1. The detailed database including receipt details and source.
What?
Serial number 1, my lord, the minutes of the meeting, my lord.
Yes.
Serial number 1.
A detailed database.
Yes, my lord. Then, my lord, serial number 4, my lord. I think my lord, 7 also, my lord.
Can it be done in this way? Madam,
There are.
when it talks about the state government and this act is the on a legislative fiat, this has been done. And must have received the assent of the governor or the president. Let us see. Can you show me the notification? 27th October 1960. Twenty-fifth October 1960. I'm also wrong. It should be 4th November 1956. Yes, that was the first time the act. Yes, yes, yes. 4th November 1956. State government to take steps. Then that is a it cannot be done because what I find is that this decision has been taken by administration of the temple committee as well as a particular department.
Yes, ma'am.
Can it be said to be a decision of the state government?
That's the second.
It is the act which is passed by the assembly.
Got assent of the president.
President.
Yes.
Now, when it is the assent of the president, I was just thinking there are two modes, either assent of a governor or assent of the president.
Yes.
Then in that event, can it be done in this way?
It is only with respect to auction, my lord, because auction has.
What is the purpose of the auction?
Once the L1 gets.
Correct. Then you will have to execute
Yes.
what? Lease,
Yes.
lease, sale, mortgage. There is a prohibition under subsection 2. You can't lease, sell or mortgage without the previous sanction of the state government. Whether these actions can be termed as a previous sanction of the state government.
Even a refer to clause number 5 in that unit section. After successful completion of the e-auction for execution of the lease deed, necessary clarifications shall be sought for the law department signing of the agreement by the mining officer.
Can you do it? Can you take any steps in contemplation to sell, lease, mortgage? Can you do that? I'm just asking.
There is a clear bar under the act that before lease or anything is to be done, prior sanction of the state government is required, my lord. Here, the documents only postulate with respect.
Have you
to-
gone through the judgment of the Supreme Court where these type of the acts or the expression previous sanction has been interpreted? What does it mean? Post facto, does it apply? The Supreme Court in at least 3 judgments have said no. Previous sanction does not mean post facto sanction. Very difficult.
Because only with respect to.
And the reason being that the DT is always regarded as a perpetual minor. How can you deal? You have to deal with the property of a DT with great precaution.
Only aspect was before signing of the agreement.
Yeah. Madam, please try to understand. The moment a steps is taken in contemplation to sale, lease or mortgage under subsection 2, then it cannot, no action can be done unless the prior sanction or previous sanction is required, is obtained. That too of the state government. It is, brother, it requires a sanction or how can you take a decision? This is in the administrative side of the department. I think the Advocate General would be the proper person.
Can be taken up at two.
Oh. That the by order of governor, it is already there. Yes, it be proceedings, yes, 15 to 19. Look into the aforementioned ever aspect that when the auction was held, it was
The date of auction is from 15/7/2025 to 25/7/2025.
15th.
15/7/2025 till 25/7/2025.
What to do, sir?
The auction process is continuing till 25/7, 25th.
Sir,
Yeah.
you are referring a section 16(2).
Me.
Section 16(2) postulates that any asset, immutable property of the Jagannath temple that cannot be disposed of or be dealt with by creating any kind of an encumbrances without the previous sanction of the government. Now it appears from these documents that the previous sanction of the government was already there.
Not even, but it is not the, your lordship, let me make a copy be given me, Lord. As I have understood, me, Lord, it is only the administrative approval of the secretary, not the government.
No, sir, it is the government. That's why I'm saying, thou, give it to him. There is a 6/11/2024, there is a letter issued by the special secretary to the government by an order of the governor. It says convey the approval of the government in respect of modalities to transfer the minor mineral sources of Sri Jagannath Temple administration for information. So the sanction has been given for transfer of these minor mineral sources. Look at Article 166(1). Article 166, sub-article 1, clause 1. Every executive action of the state shall be in the name of the governor or approval of the governor. Now, this approval has been granted. And this is an executive, the exercise of powers by the state. It is not a legislative powers by the state.
Yes.
It's an executive power. And if the executive power is to be exercised in the name of the governor, then this order is there, approval. And that too in November 2024, much prior to this. And then if you come to section 3 of Jagannath, the Sri Jagannath Temple Act, look at it. Page 177. Please come. Top. The Puri Sri Jagannath Temple Administration Act shall be deemed to be a part of this act. And any of the powers and function of the state government, kindly visualize, under the said act shall be exercisable by the committee. So it is the committee who substitutes the state government. And now the committee has also taken a resolution. Where is that? This resolution is taken on 25/4/2025, prior to the publication. And they say that the administrator has already said no difficulty. Then how can you challenge this on this ground?
Under the Lordship, kindly say, even if there is a, they have taken the decision to auction.
Can you impinge? Because immunity is given in the Constitution. That if the governor has exercised his power,
Absolutely.
executive powers, then it will not be called in question before the court.
Even if there is an order of the government to auction or lease it out.
Yes.
Therefore, the other day I have made the submission that yes, the auction can only be made in a manner known to law.
Give it to him. Who has signed it? By an order of the governor?
Special Secretary to government.
So, And this is a resolution of the Jagannath temple administration. Give it to him,
by the committee.
administrator. All dates are prior to that particular auction. So previous sanction means there must be a previous sanction.
Yes,
These are all dated prior.
Miller.
So it will be taken that the previous sanction was granted by the government.
Miller.
So section 16(2) fulfills,
Comply.
no difficulty.
Miller.
Section 3 also confers powers upon the administration.
Miller.
So that is also fulfilled.
Miller.
Now, what?
Miller. Now the question is, Miller.
Now,
There
you are in PIL, sir.
Miller.
You are in PIL.
Yes, Miller. Now,
Remember,
Miller.
it is not a ordinary writ of mandamus, sir. It's not an ordinary writ of mandamus.
Miller. Now the question is, Miller, even if they have got the power to lease it out or grant the auction bill,
Correct?
can they override this dictum of the apex court in Deepak Kumar?
What Deepak Kumar said.
Deepak Kumar says not less than 5 hectares.
Sir,
Miller. No,
I am really, I have to look into when you talk about all those judgments,
Miller.
it says that it is not desirable that to conduct an auction in respect of a particular land, which is of a particular area. If they wanted to do an auction, can it be termed to be a void one? It's for better. It's a more clarity, the more transparency which is brought. Otherwise, if they do it secretly without any calling for an auction, will it not tantamount to some kind of a nepotism or a favoritism by the authorities?
Miller.
So it is better to have the auction.
Miller. They have to auction, Miller.
Correct.
And they have to auction keeping in mind the apex court dictum.
So what is it says? What it says that up to that area, you did not have to go for auction.
You have to go for a cluster auction, not in the individual auction. They say,
Well, one NIT, they have invited those, all the area or the land has been incorporated therein by one NIT or one auction. Where is the difficulty? Show us the Deepak Kumar, what it has said. Show us.
2012 for
Please show us.
629.
Let us see. I am also in fix that what you are saying is actually decided there.
Yes, Miller.
Second copy.
Second copy. I mean, I have only one copy for your lordship.
2012. 2012 4 SSC 629 Deepak Kumar versus State of Haryana. 12-4. 6-9.
చెప్పండి.
Yes.
Now, Lordship has seen paragraph 22. 22.
40?
22.
Huh.
Yes, ma'am. So the MOE, we have
Sir, this paragraph 22 was the recommendations of the
Ministry of Environment.
environment.
Miller.
And this recommendation says that minimum size of the lease should be a 5 hectare.
Miller.
Why? Because they say that there were many things which was creating imbalances in the environment.
Miller.
So they say that if there are smaller one, then what to do?
A cluster.
What cluster?
Miller, that.
What is the meaning of the cluster?
Miller, putting all the smaller mines to a basket here.
It would remain again. What they have to do is, suppose if there are only 2 hectares of land available for mining activities, surrounding lands are not containing any minerals. What they will do? Tell us.
With that smaller mines area, along with other area.
That is please, what is this? Is it not a farcical exercise? One pocket here, another pocket here, third pocket here, fourth pocket here, fifth pocket here.
Yeah.
But these are all separate at a distant place.
Right.
Cluster. It does not say so. What it says was that if there are smaller ones, you cannot segregate.
Right.
Suppose the area is, say, 25 hectares of land which contains a minor minerals or a major minerals. You cannot divide it and say 1 hectare I'm giving, 2 hectare I'm giving, and then different. You have to do it in a cluster. Either you say minimum size will be 5 hectare. So if it is a 25 hectare, then you can simply divide it into a 5 hectares
That's it.
and then you can do it. You cannot do it in a 1 hectare or a half hectare and then give. But if there is none, if it is only this much is available, then can you? I'm just asking. The spirit of the judgment is not that. The judgment was that they were splitting.
Yes. The splitting and a smaller. batch.
Then this says that why? If it is a large, you cannot give it to one. Then in that event, make a cluster.
Right.
So cluster will take some areas which should not be less than 5 hectares.
Yeah.
That is what the spirit of the judgment is.
And keeping the para 22, they have given the direction in para 24. Now, after this judgment,
Not para 22. They have given a direction in
para
para,
24.
not para 24. They have given a direction in paragraph 27.
Let 27 and 28 both have to be read together. Right? We therefore direct all the states, union territories, ministry
To
of
implement that recommendation which you are referring at paragraph 22.
Miller. That 22 recommendations have been taken into consideration in paragraph 24, Miller. And
The direction for upon all the state is under paragraph 27 to take care of that.
Yes,
That's a mandamus.
Miller, 27 and 28 are the mandamus. So, after this judgment, Miller,
It was a river bed. I know that is what is there.
yes, that particular judgment is relating to river.
So,
Miller.
because the Supreme Court was considering that if there is an unregulated and uncontrolled the mining activities, that is means sand quarries are permitted, then it disturbs the natural flow of the river as well.
Absolutely.
And sometimes the river becomes so unregulated or uncontrollable that it will impact the other agricultural land. It will impact the habitats of the human being or a nearby person. So there must be some kind of a regulation which is to be
Absolutely.
brought. And that was the Supreme Court has said that there is a distinction in those. Now it is a case of which one is here is a case of a granite. So granite is not in abundance.
Miller.
If it is, this granite is available only in the 2 hectares of land,
Miller.
then no mining activities can ever happen.
Miller, no. What my submission to your Lordship Miller, keeping in view this direction of the apex court, this state has amended the rule in 2016.
True.
Miller.
So
There your Lordship may kindly say Rule 5 will.
yes, what rule 5?
Rule 5 of the Odisha
Minor minerals rules.
Yes.
2016.
Yes.
Yeah.
Your Lordship may kindly glance. Rule 5 says
Yes.
that no less than 1 hectare is not permissible.
So it is more than 1 hectare.
No.
Huh?
Miller, that your Lordship.
Where rule 5?
Your Lordship may kindly come to Rule 5B.
Yes.
Minimum area. Miller 6 Miller. 6 is the minimum area. 5 is the maximum area. The minimum area that may be granted under prospective license for mining lease or mining lease shall not be less than 1.
But proviso gives a pass to them.
But for the reasons recorded in writing,
So that is what is there recorded in rising, though power is there, though they cannot give it below 1 hectare,
your
but
lordship has
provide to.
seen the state government recommendation here. There is no recommendation for grant of lease less than 1 hectare. Here the special privilege was given under Rule 5B.
My lords, here in this case, my lords, 4, 5, 6 of the bill document is one cluster, my lords. 4, 5, 6 is one cluster. Page number, if I let me see, page number 20.
Yes.
Serial number 4, 5, 6 is one cluster. And as per rule 31, it has been done, my lords. And serial number 3 is a single lease because it is more than 12, its area is 24.89 hectares.
What about 1 and 2?
1 and 2 I have just received instructions that 1 and 2 has been withdrawn, my lords. There was an corrigendum issued on 18/6 where one which is.
Because they are coming under one khata number and they are coming under the same plot.
Yes, my lords.
So this is what a cluster, and if it is taken together, that it exceeds 1 hectare.
Yes, my lord. 4, 5, 6, it exceeds 5 hectares as per the rule, my lord.
Yes.
3 is more than 5 hectares and.
No doubt.
And
Only
one-
1 and 2 you have withdrawn.
Yes, my lord. If I have it on.
Now, then what is a grievance? Even a cluster, according to Deepak Kumar judgment, you have accepted. And then 1 and 2 has withdrawn, which is less than 1 hectare, no problem. 3, you yourself says is more than 5 hectares.
Yes, I have admitted what is this. But 4, 5, 6 is one.
Is a one cluster which
That is
exceeds.
not there in the notice, that what my lord.
They say one cluster and they have withdrawn 1 and 2. There's nothing. There's nothing in it. Unnecessary.
Lord, that is only a submission made before your lordship see.
Yes.
The entire tender.
Do one thing. Can you file all the bring on affidavit all these things? The instant public interest litigation is taken out by the petitioner. Assailing the auction notice. Yeah, assailing the notice inviting tender dated 9/6/2025 for Not necessaries, madam, are you not? We are not going, if we go pass an order against them, that they have a right to be heard.
Petitioner, I pay for tomorrow. So it's a common sense.
Then you come after, in the next week.
Item number 3.
Transferred. The delinquent officer has been transferred from that place to Lordship.
Yes.
Now it has, there was an inquiry by the ADA, he's found for minor misconduct, your Lordship.
He found,
From the ADM inquiry,
uh,
now inquiry was conducted,
uh,
from that it was ascertained that she had some minor,
This- some irregularities or a
hiring of vehicle and maintaining the register and all. So she's been transferred from that post.
okay.
Now, your Lordship, it will depend on that, the government prerogative as to whether they want to proceed with the department inquiry or not, proceedings or not.
So will you not take steps? Even if it is a minor, it
Lordship, I-
invites some penalties.
Your Lordship, I have intimated the Cora could collect at least transfer, your Lordship.
So when you can file your affidavit, you have to file and disclose all those affidavits in the affidavit. When?
2 more weeks, your Lordship, the collector will join us.
10 days.
Item 4.
Take the POC, your Lordship, for the final counter affidavit to be standard.
Which one?
4, your Lordship.
You have filed?
No, your Lordship, I received the,
My surrender application is pending from February
Yes, your
25.
Lordship.
She
But
has.
there's
It
last
is
submission, they
submitted,
said
it
that
is
it's
submitted
there.
by the
But the last-
council for the state that she has received the Parabai's comment.
Wait for it password. So that is used to file an amendment application.
Then come on the Monday.
Monday.
Item 6.
They're not filed counter.
This is regarding the renewal of license, provided at least 50% of the demanded.
So first was under.
Chauffeur is understanding.
So unless the show cause, this matter is decided, what can be done? What was the interim order which was passed?
Lordship directed that the.
Will deposit 50% of the demand by, have you deposited?
No, I'll.
So then there is no interim order. We will vacate the interim order. We'll vacate the
I'll
interim.
obtain instruction, Lordship, and taken up next week then.
Otherwise you show 50%. There is an order.
Lordship.
17th May you were supposed to.
Yes.
Next week. Adjourn on his prayer in the next week.
Item 7.
Yes.
Second one also. Procedure PI matter relating to the irregularities had happened in the innovation project of Katak 2010. In 2022,
What has happened? What you say? Construction, financial irregularities in construction of the temple.
there are irregularities as well as the construction, regarding the construction, the low quality of materials have been used. And we are already 3 years of past. The things.
Where that was located by the Orissa Beach and Construction Company. So they have to respond, my lord, and so also the Cuttack Municipal Corporation have also been
Who
included.
floated the tender?
The Orissa Beach and Construction Company, OP8.
OBNCC, Orissa Beach Construction, they have never been noticed. Madam.
I'm asking how they got an authority to float the tender.
That is on. Because that is a public sector undertaking on behalf of the state. They were authorized to float the tender for construction.
Our parents department is works department,
Okay.
OBCs.
So you have been served?
No, madam, copy of the.
Copy
requisition has
you
not been
served?
brought to us. Not issued.
Public interest litigation, madam, you should
We have instructions.
serve the copy for the first time.
Yes, ma'am.
Yes, he is.
Day before yesterday, a letter has been come from the government.
I am proposing an amendment in the Odisha High Court rules, if all these lawyers, they agree that no writ petition, either in the nature of public interest litigation or mandamus or certiorari or quo warranto, would be listed before this court unless an advance copy of the said petition is served upon the parties 20 or 48 hours before. So this will be avoided.
Last 2 dates, state has said that we will take instruction. We have not been noticed, so we didn't know regarding this case, madam.
Serve the copy.
Yes.
The advocate and the court of the petitioner is directed to serve the copy of the writ petition upon the appearing counsels, except the state.
The mail. Construction of a road from construction of a road, 200 feet road. From Institute of Mathematics to Ekanra Canal.
Yes.
This is the parallel road from Joydev Dam to Nandan. This is very much essential.
Yes.
But the tendency of the secondary petition, madam, the road work is installed.
Road was constructed.
Partial
Partial.
construction.
Yes.
But the tendency of the secondary petition.
This is the second.
This is the second petition. First is
497 of 24.
the list matter. The road work is installed by the since March.
Oh. What are you doing?
Your Lordship,
This is a
the-
very important, this is an arterial road,
My,
yes,
the only means of access.
as per the Indian Road Congress, road work has taken up.
Your Lordship, this PIL should be dismissed, Your Lordship, because the affidavits that we have filed in this PIL, Your Lordship, is sufficient to as the answer all the questions that is there in the first.
There are ditches, there are potholes.
Because the Lordship of this PIF, we have given, Your Lordship, there was a comprehensive development plan, which was framed by the BDA, Bhubaneswar Development Authority. The first plan was released in 2010, where this road was shown in the previous, as per the previous alignment. Then the alignment was changed and the comprehensive development plan was released again in the year 2018. After that, the road work started. Since the alignment was, a sharp curve was there, they changed the design. And also the fact that many more buildings and all would be demolished. Here, when you change the design, there were less of demolition and more of the government land where they had to build the road, and there would be less of acquisition of private lands. Now, these the petitioners, they file saying that they are taking over our rights in the forest area. Yeah, they are building the land. That was not the case. We gave a reply, the forest, as per the forest department. Then the SCST department was called into question to answer whether the prayers of these petitioners are genuine or not. The SCST department also filed a reply stating that 238 number of people were instituted into, yes, forest rights, and all their requests were dismissed. And 2 of the petitioners were also there. So they are encroachers because they have encroached upon those lands after the year 2005, not before that. And it is pending, Your Lordship. And they're only at the forest, the regulations have been followed, Your Lordship. Forest land has been due diverted. They have been applied for, diverted. There is no have inhabitants of forest dwellers there.
Still occupied.
Yes, your lordship, they're still occupied. They have been encroachers.
Approaching the court with this PIL so that they can not
Yes.
be touched.
Yes, yes, your lordship.
So the road is complete or
Your lordship, some
that area because of him it could not be.
for him, your lordship. Otherwise, the load wherever the district administration and BD have given them encumbrance-free land, they have constructed the load. Here, these petitioners are the ones who have stopped construction of the road. The SC/ST department is also setting them to be, they have heard them and they're setting them to be encroachers, not forest dwellers.
They challenge that
No, your lordship.
not challenge.
No.
In Savaitam,
Item I am looking at.
yes, but that is, I am for the private opinion, but I am petitioner council is upset.
He's
Yes,
not
madam.
coming.
I'm the
First one.
One
He is
five-
support construction of the.
I am for the construction of the.
Of Digi and others.
I am for the construction.
He's not coming, your lordship. After we given the counter of the SC department and the forest, after that he's not attending.
No, last occasion he was here, I find from the order 2/4. 2nd of April order.
Yes, madam, your lordship directed to serve the counter copy to the petitioner on that day. And,
Because each time first the counter was served by the roads and buildings authorities. He said that the collector has been told to file an affidavit, why it has not been filed. Then your lordship, we served the copy of the counter of the collector. The collector has said all these things we have done. Then he argued. Again, the SCS, then the acting chief justice, Justice Sinha, he ordered that you file a reply by the SCST. We again filed a reply of SCST. That was also served. Now we're saying counter is not served.
the road construction is obstructed by the subitem petitioner there. He is taking different plea and adjourning the matter. Collector.
You are not standing in the way.
I am supporting for construction of the road because my
You are
private
supporting.
land. Yes, madam.
I am also supporting. I am.
Oh. So they have come from your rescue.
And the other petitioner in the subitem, he is playing
Just
identity
imagine we
role.
are all sailing on the same boat with you. So
Traffic congestion is so much more from Jagannath to Nandankanan, your lordship, in the peak hours in the evening, a patient, one ambulance cannot move, madam.
Yes,
And
your
in the
lordship.
ring road, that is 200 feet road is badly essential. And they have also followed the IRC norms and to the earlier, but the petitioner in subitem is saying that we are advancing forest rights.
Yes, your lordship. He-
But collector
Number of
counter
bar.
is very clear, my lord.
can you inform him?
Your lordship, I-
We are keeping this matter on Monday and will dispose of the matter.
He is not picking up telephone calls. He is staying at bonuses, not in the headquarters of Cuttack. That is the whole problem. Subitem petition.
Please just contact him.
Yes, sir.
Just give an affidavit that you had a talk with him over the telephone and informed him that the matter would be listed on Monday.
Yes, your lordship. I'll.
And just we will proceed on that basis.
Okay.
At last, the
Item 9.
Your Lordships, in item 9, I am appearing for the petitioner. I beg to appear virtually, Your Lordships. Your Lordships, this matter has become infructuous, so we seek necessary orders.
Why do you people use the word big?
Sorry.
You have a right both under the Constitution and the statute to represent the person. And why you, for appearance, why this word big? You could have said you are appearing for the person.
Your Lordship, sometimes it becomes inconvenient because, so for the purpose of convenience, we say that.
We are living in a country, we are not in a, under the colonial rule.
I am obliged, Your Lordships.
Yes, the council for the petitioner submitted that the incident, which petition has come in process. And we will dispose of accordingly. In view of the above, the incident petition is dismissed as in process. There is no interim order here.
No, my
no,
lord. Last occasion I directed to obtain instruction. There no interim.
Item number 10.
Highly obliged.
Obliged.
No, and to answer so for that prohibition under the Ujjala Secretary Statute of Guchur,
This is a butcher.
Guchur landlordship.
It is recorded in the name of Sri Jagannath M.R.PATHAK. And the act mentions provided.
A butcher land.
No, my lord, the act, if I may read just one line, the proviso, my lord, section 3 proviso, my lord.
Of?
The Odisha Government Land Settlement Act 1962.
Section?
Section 3 proviso, my lord. Section 1 proviso. Provided that no
Section 3. Let us read section 3. Oh, sir. Yes.
provided that no government land recorded as butcher millers. Here it is recorded in the name of Jagannath M.R.PATHAK.
No. Because it is a butcher for the grazing of the cows belonging to the Lord Jagannath's administration for the chapter.
My as per the ROR, it only mentions the name and the purpose is not mentioned. And even in the definition of government land, it's
I have seen the garment land, that's why belonging to the garment is the word I have found. I noticed there is no difficulty.
So this is a section statute matters governing the government land owners. The dereservation is under this act only with respect to government.
Now, where is the there is a provision, it says that the nature of the gochar lands cannot be changed unless there is, can a person, even if the private litigant, change the nature of the land without seeking a permission from the government? Does it targets the user of the land other than for which it is so recorded?
Provided that no government land record is gochar.
Question is, the government land is defined in section, that is, D is there.
Yes.
B.
Means any land that's
Belonging to the
Belong-
government. Now, my question is, belonging to the government means must be recorded in the name of the government.
let's see.
So if it is recorded in the name of a Lord Jagannath, it cannot say that it is belonging to the government.
But rule 4, let's you kindly see. Rule 4, let's you kindly see. The directional principles are there, let's see. For any gochar land, let's see, that is.
No, understand, sir.
Yes.
He says that so far as the government is concerned, they are not answerable because this land does not belong to them. If I correctly understood their stand. So how they are answerable?
Yes.
Because I know the law of the other states
Yes,
where
yes.
that the Land Reforms Act, there is a prohibition. It says that if the nature of the land is recorded in the record of rights, say it may be homestead land, it may be an agricultural land, it may be a pond or a tank or whatever, then nobody would be permitted to use the civil land for any other
purpose.
for which it is so recorded.
So recorded, yes.
He can, there is a provision, he has to approach the revenue authority there.
That's it.
Initiate a proceeding,
Proceed.
seek for a permission to change.
Yes.
And if the competent authority permits the change of land, then the notation is done or correction in the record of rights are done, then this can be permissible. There is also a criminal liability attached.
That's it.
That is, whoever is using the land other than the purpose for which it is so recorded, then years.
Punishment there. That is our law permits.
But where is that?
Yeah.
In Odisha Land Reforms Act is there.
This is what I really wanted.
Section
That is there. There is a violation.
Section 8A, let's see. That is in
8A is a settlement.
Odisha Land Reforms Act.
It is OP, under OPL, it's lordship settlement.
Oh,
In
In OPL, that is
But
settlement.
under OLR, lordship.
It is in respect to the agricultural land. If any person wants it to be converted into non-agricultural purposes, he has to obtain the permission.
The Gochar land can be termed as an agricultural land. What is the definition of agricultural land? So it includes the raising of the crops and grass. So for the purpose of Gochar is the raising of a grass.
Grasslands.
Yes. So what they are doing, what is your grievance?
Lordship, for mining activities, they put to action under the OMMC rules, Lordship, that is.
Can they do it?
Well, it's here.
How can you do it? If land does not belong to you, how can you do it for a mining purpose?
It's similar in the, with respect to item number 1,
Correct.
same,
Same documents are there.
Yes, my
on
lord.
this land.
Yes, my lord, same documents, my lord, same option notice is under challenge, my lord.
Same action, Lordship.
So, according to sanction under section 15, my lords, and Gochar as per this act is not
That
up.
means Gochar land can, without the conversion having affected. Very correct. That's why he is correct in saying that this matter stands on a different footing than the, we must have obtained the permission. But if it is the Gochar land, there is a special clause. And the prohibition under the Land Reforms Act is there. Agriculture is defined in that act to mean a raising of grass. And Gochar land is meant to raise grass. Raising of crops or grass or garden to use agriculture, daily farming, feeding and keeping of livestock, development as special of for forest or incidental this. Is that the record of right which you are saying the record in the
Page number 61.
page
Page
61.
61. That is in Manukula.
So you can't read
Lordship.
the whole problem. Both of us cannot read. What is written? Can you read?
Lordship, it is written, Lordship, Sri Jagannath Mahaprabhu Vijay Puri. Lordship.
In the first block.
First block, Lordship.
Yes. What is written?
Sri Jagannath Mahaprabhu Vijay. Administrator Jagannath Mandira Parchalna Committee, Temple Administration, Lordship.
Then plot number is 602.
Lordship. 602, Lordship.
And what is the third column? Below 602.
Rakhit Anabadi, Lordship, that is.
Rakhit
Anabadi.
Anabad. What does it mean?
Means it is a, let's say, pure government land, let's say, that is it. It can be used for the purpose of any other purpose, Lordship, that is. It can be.
Then it is not a Gochar land.
No, Lordship. But the particular plot which is in put to action, Lordship, that is page 62. Next page. The particular plot.
This is 602.
The khata number is 602, Lordship. The plot number which is put to action, Lordship, page 62. The next page, Lordship.
Yes,
Lordship, third, that's 150, plot number 150.
yes.
That is Gochar, Lordship. The next column, Gochar. The particular plot, Lordship, maybe Lordship, other plot, maybe Rakita Navadin other. The particular plot which is put to auction.
Rakhi Tanavadi is a government land.
Government land, Lordship, government land and
What is the
Lordship.
exact meaning of this word?
It can be used for Lordship. It can be settled, Lordship, in fact. Lordship, the real meaning, it can be settled against. It can be settled, Lordship. Rakita Navadi can be settled against any person, Lordship.
What is the meaning of this Rakhi Tanavadi?
Lordship, it is a.
I have come from a place where these words are not used.
That's the real Lordship. Rakita Navadi.
What is the meaning of this word?
It can be used for any other purpose other than homestead.
Other than
Homestead.
homestay. Okay. So we can safely go not a homestead.
It is Lordship, speaks of Lordship uncultivated land or reserved wasteland. In English, Lordship, that is
Undivided,
uncultivated land, Lordship.
uncultivated.
Cultivated land or reserved wasteland, Lordship. Reserved wasteland.
So how can you take it as a gochar?
No, but it is speaks of the entire whole Lordship. But the lot which is put to auction, specific Lordship in the auction notice, that is 150. And 150 is this Gochar. The next page.
And this 602 is a khata.
Khata, Lordship. As a whole, Lordship, that is. This khata consists of different plots, Lordship. And
Belonging to one person.
temple administration, Lordship.
One person.
One person.
So one person, one khata.
Khata. Khata, Lordship.
Correct.
Correct. Lordship.
So say he may hold 50 properties,
Lordship.
but it will be included in one
In
khata
one khata, Lordship.
at a different place.
Different places.
Maybe we call it a khatiyan number.
Khatiyan number. Lordship, Khatiyan number.
That is the khata number when he says, so I was just trying to understand.
Lordship, that is Khatiyan.
I know khatiyan.
Khatiyan, Lordship. It is
So
Khatiyan.
it is a one man, one khatiyan.
Lordship, written also Khatiyan, Lordship.
Oh, I understand. It is only for the purpose of making a person responsible
Lordship.
for a land revenue
Land revenue, Lordship.
in respect of the entire land.
In one village, one revenue village, within one revenue.
Great. So how it is a gochar, how can it do that?
That's with respect to what the DT's administration would be answerable whether any.
Can they permit you to go for a gochar? I'm asking, you may be permitted with prior sanction, previous sanction, no doubt about it. But if it is a gochar, can you, I'm just asking, without converting it into any other land? Yes.
This act is not applicable in the present case.
Well,
Well, it's because e-reservation is with respect to government land under this act, my lord.
no, I'm talking about the Odisha land reform.
Yes, ma'am. Only with respect to section 8A of Odisha Land Reforms Act, it talks about conversion, my lord. That, my lord,
Conversion means there is a prohibition.
section 8A talks about.
Means it what it says.
Talks about notwithstanding anything contained in so and so, conversion of agriculture land.
So unless the conversion is done, then it cannot be done. How can you permit this land to be used for some other purpose than for the butcher purpose? Unless you convert. If you look at section A, there is the provision, if he using the land for any other purpose under the land reform, then he is liable to be evicted. What to do? How can we use yours? Tell us.
If I may request my lord, point members. In this matter, my lords, this matter may be also called upon on Tuesday, my lord, and notice to Jagannath Temple Administration, my lord.
Huh? You can't proceed.
This matter may also be called upon on Tuesday, my lords, and notice to
Then law is going to be here.
Already, yesterday they have lordship. I was making mention, yesterday was.
tomorrow is the last.
Tomorrow is the last, but you have completed
It's
yesterday.
continuing, my lord, started from 16th July.
Today is the last, but out of.
Then tomorrow is the last date of submission.
No, from 16th July to 25th for continuous proceedings.
Today is the last day of action lordship.
No, you are meeting a mining activities. You have floated a tender
Yes, ma'am.
to settle it. What is the last date for submission of the tender?
Yes, that is my lord, last date was of my lord.
Last date was 28/6/2025 lordship.
28/6, my lord.
Now,
Date of action lordship 25th is the last day.
25th is the last.
20 last day.
It
Yesterday they
starts
have
from-
completed. We can so yesterday they have completed 3 lordships items. Today is the last lordship.
It started from 15th July, it is still 25th July, my lord.
don't finalize it. Particularly this thing.
Yes, ma'am, so only.
Particularly this. Huh? Huh. The instant repetition is taken out by the minister. Challenging the action of the government.
Item 11.
In this matter, the statement is recorded and was produced before the CW. Thereafter, for parents, since handed over to parents. Yes, ma'am. And received instructions by the CWC. Yes, ma'am. Paragraph 4 and 5.
Right.
Lordships make a small mention before lordship guidelines. With regard to item 14. Not today, I was requesting tomorrow or before coming to
Item 13.
Item 13, can you take it out of both ways? But the petitioner is enjoying the interim order. This is 10th and non-liability is constitution of the appointment process is already going to end. My lord has already removed all the hurdles in that appointment process, and yesterday 210 crores have been sanctioned for.
already.
Yes, sir.
Which was the, you are for the. Yes. The about on behalf of the.
I am for this. I am state GS.
The all steps required for. This steps required for making the traveler functional has already, I have already taken. It's called 14.
Item 14.
Since this matter belongs to 73B matter. Okay.
You have checked?
Yes. I am subitem.
And
Item 15.
It's a revenue appeal lot. What is the central position of law? Not. Question of law that arising out of the order.
My lord, I appear for the respondent in this matter. My lord, I am assisted by Mr. Dhanuka, who is appearing physically, my lord.
That the Dhanuka is appearing?
My lord, he is assisting me. We are appearing for the respondent, my lord, the assessee.
That we have formulated the question of law in page 14 of the appeal memo. So for page 14 of the internal page of my appeal memo.
Well, subject to correction by Mr. Shatpati, well, the question now stands answered by the judgment rendered by the jurisdictional high court.
Yes, I'm coming. Please wait. 2 to 3 minutes, please wait.
Very well.
So, my lord, so far as the italic 2 is concerned, no? Yes. That period has already been decided, so we don't have any issue on that. Italic 2, question of italic, whether on the fact and second the case, the learned traveler is correct in holding that fee contained of iron or fine for the purpose of levy of custom duties shall be determined on W20 basis
after any conversion when the EMAS formula shows conversion has no statutory basis. So that has already been not held by this honorable court that WMT is permissible, no DMT is permissible. So the next one, the issue will the petitioner will not has 13 sitting bills. 13 sitting bills at one go. What he did not, he has included all the bills in a one format and not exported the bills. So lordships kindly see this section. Section not customs. Section 17, 1 second of the Custom Act. Customs.
Yes, yes.
The assessment of duty. An importer entering any imported goods under section 46 or an export entering any export of goods under section 50 shall save as otherwise provided in section 85, sale pass a duty, if any, levy on such goods. The proper official may verify the sale assessment of such goods and for this purpose examine and taste of any imported goods or export goods such part thereof as the case may be. Then we'll not verification all this. We are not on that. Then you'll also kindly see section 50. Entry of goods for expedition. High 50. The exporter of any goods shall make entry thereof by presenting electronically to the proper officer in case of goods to be exported in a vessel or aircraft as shipping bill, and in case of goods to be exported by land, a bill of export in prescribed forms. A bill, that means one bill. Then you will also see the order. Now the operating part is
Order is at page.
it starts from page 80.
Yes.
If you lordship see the finding of the tribunal, page 20, internal page 11 of the order in running page 28, paragraph 12.
Yes.
We find the allegation in the case against the respondent is that they are splitted their 5 export consignment to 13 consignment in which 7 consignment fee cut is more than 58 and which respondent discharge a duty rate of 30% and remaining 6 will with test report show that the fee contained is less than 58. The respondent did not discharge the export duty. So our stand will not if it's clubbing all these. Then the accurate fee content has to be determined. But here they have clubbing all this thing and come to a finding, and the tribunal come to a finding that it is below 58. So there will be no, there will be exemption of the tax, duty.
Duty.
Yes, that is what the whole issue will say. But so far as the DMT and WMT, that has already settled by this honorable court and key and all these things, and Supreme Court also decided and notification also issued. So now this question has to become law has to be not in accordance law. It cannot go beyond that. The statutory authority, I mean the adjudicating authority, later on will the tribunal. Yes.
You say that
It cannot be splitted.
No, it's 40.
Yes.
Yes.
then they have to shipping bills and in case of a goods, such and such in a prescribed form.
Yes, prescribed form is not in that is not there, Lord. I'm just
The question boils down to the word which is used in the section. A-bill,
AB.
whether it follows a similar bill or it can be presumed multiple bills.
That AB.
I am looking in the perspective of the General Public Act. It says that similar sometimes means plural and plural sometimes means similar can be the voice of us.
But here we are,
When you say the word A before the bill is used, does it mean only a single bill?
because Lord, so far as the context of the Custom Act, in the Custom Act, B Lord is Lord the iron ores here in this case has been fixed on a different grids. So therefore, Lord,
It's a very important
document to determine the duty.
For the purpose of levying the customary bill, determining the rate
Yes.
and the modality, whether it comes under a particular classification.
Yes.
That
is what matters.
So now you are, according to you, A bill has to be interpreted in a similar manner. So they should separately, they should have given a separate bill for each. They cannot go up to you.
Right. That is the standard. I mean, so far as this of the bill is concerned.
In judgment on that, you have got
No.
bill.
No, not yet. I have thoughts.
No such things. There
I have
is,
thoughts.
there is one dedicated, I think the chapter is not there, but I can say there's a inform. In the GP Singh's statutory interpretation is A and B, if they are used in a statutory provision, what does it mean? Sometimes it is A, sometimes it is A, and sometimes it is used as D.
But here will not be fiscal statute. Will not we have to read it.
This is a statute.
Yes. But always fiscal statute not in favor of the revenue so far as.
What are you talking about?
But interpretation are always will
I
not.
think the reverse is true. Reverse is true, then what do you say?
Well, that is what Lord, Lord, my case is only confined to this. Lord, there is no such other issues more.
Well, subject to your lordship's kind consideration, when may I just give a quick reply subject to your lordship's consideration?
Each stage of admission, do you have a right of audience?
My lord, ordinarily there is no right of audience. That's true, my lord. It's order 41, classically.
Yes, classical example of order 41, rule 11.
Rule 11. But my lord,
And
since
you know about Justice, now I can share this quote as well.
I told my juniors.
A.K. Ganguly,
Yes.
there in a division bench has said, in Surinder Kaur's judgment.
Yes, my lord. Then, my lord, we have to go back to
the Chief Justice, so we take it, this court's view also.
My lord, may I just take your lordship back to your lordship?
Supreme Court view as well.
Supreme Court is Khitish Chandra Purkai, the first one. Khitish Chandra Purkai, the notice of appeal has to be given. Then only, my lord, the respondent would have any opportunity to reply. But only, my lord, if
But
your
the only
lordship,
thing is formulation of a question of law, substantial question of law,
Yes,
and
yes.
then you will have a right of audience.
my lord, we are at that stage subject to your lordship's kind consideration.
Why?
My lord, because, my lord, today they say question number 2, which is really the real question, now
No,
stands.
they say the question number 2 has already been
Well, the
settled and
question number
decided
3
by this
is not
court
in-
and
Yes.
Supreme Court as well. And in fact, they say notification is also issued in
Yes,
this
yes.
regard. So he's abandoning that. He's
If
not
he's
saying that I am going to argue.
Well, if
But
he's
he has
abandoning
flagged an
that-
issue
Yes.
that when the statute has used the word a bill or a bill,
Yes.
then ordinarily it should be construed that it is construed in a singular manner.
Yes.
And if you have clubbed or you have
Well, I have not clubbed. My lord, I had, my lord, these were 7, my lord, it was 7 consignments split up into 13. Kindly take paragraph 2 point, page 25, 2.3 of the, my lord, the order. It was revenue's case that you could not have split up. My case that I had split up. Revenue said it cannot be split up. Revenue said that it has to be clubbed for each
Huh?
vessel.
Now revenue is taking a different view.
Now revenue is taking a different view. Well, this is what is happening. My lord, kindly take paragraph 2.3 of the order.
Where is that?
Paragraph
Mr. Sotapati?
2.3, running page 25.
Page?
25.
Yes.
Despite sustaining the allegation of having split a single
Paragraph
2.3, I'm sorry, my lord. Internal
2.3
page 7.
starts from paragraph page 24.
Despite
sustaining the allegation of having
Despite sustaining the allegation of having split a single consignment into multiple shipping bills. So this was the allegation that I had split up single consignment into multiple shipping bills. And now the revenue in the appeal says that this could not have been done. This was their case. Then, my lord, weight metric ton method had been applied. Once weight metric ton method has been applied, it has been found that I am entitled to exemption. This was their case, my lord, not my case. The appeal rounds countered to their case.
That is ordered by the adjudicator authority, but revenue challenge by a tribunal.
Well, despite sustaining that this was the case of the revenue.
Here, if your stand is that they have split up a single consignment.
Yes. They passed the order that has been challenged by the revenue tribunal. And you also see paragraph 3. What is the submission before the tribunal? Page 26, interval 9.
Again, splitting up.
This is also, they say that they have split up.
Splitting up.
They cannot. But now that is what your case is. That some consignment may contain more than 58% of the iron ores. Some may contain less than 58% of the iron ore. If it is less than 58%, then there's no duty is leviable.
Right.
If it is more, then the duty is leviable. So they have segregated that these contains more than 58, duty is leviable. This contains less than 58, duty is not leviable. you say, how can you split up? You should tick as a whole stock.
In other way, Milord, if
This
you-
is what
both
your
way-
your stand was.
Milord, if both we calculate, it is below 50. With all Milord sincerity, I can submit. Milord,
That is it, my lord. That is it.
if Milord
That is-
calculate it, so Milord.
So that is what your whole contention
Milord,
was.
dispose it of.
Well, they can't.
Tribunal has accepted the contention on
This can't. You can't blow hot and cold all the time. Before one authority, you took another stand. Now coming to the High Court and saying that it's different. No. He has ignited the thing, though he has no right.
Yes. Milord, I come to.
The High Court, WMT has already been.
Yes, yeah, it was assist. I was argued that. One case you not see the C. 48 or 40.
Where is the appellate provision under the Customs Act?
That
That is section 130. 130.
130.
130.
I'm looking after such a long time. Oh, the 130, the tax tribunal has not been constituted.
No.
So here Milord, against this extra order culture. Tribunal's order, man.
Tax tribunal, my lord, has not been constituted because of Madras High Court Bar Association judgment.
National tax tribunal.
No, I find from this book that this particular 130 has been amended.
Well, that amendment was
Saw the light of Madras High Court direction case Constitution National Tax Tribunal. That has been not been.
that Madras Bar Association case.
Madras High Court, what it did?
The Madras Bar Association went up to Supreme Court challenging the constitutional validity regarding the constitution of these national tax tribunals, having regard to the fact that the tribunal members were administrative or technical members. So that
on that score that they have
that score, your lordship, yeah, absolutely.
legal expertise or acumen in this regard.
Absolutely.
It is continued. So by central exchange and service tax and the custom.
And also income tax, man. Also income tax.
Yes, the order passed by the tribunal among such as such for determination of any question having a relation to any question related to. So it's not a substantive question in that sense. In the income tax, no. It's substitution 3. Where the High Court is satisfied that the substantial question of law is involved in it itself for taxation. So it talks about the substantial questions, though they say any question, but it is a substantial question. Give that judgment.
No, it's at page 69. I'm sorry, I'm carrying the entire compilation. Page 67.
The lordship is referring to KI International.
Yes.
I relied on a judgment regarding blowing hot and cold of Calcutta High Court, that is Justice Ashutosh Mukherjee's judgment in this matter. AI 24, Calcutta 600, my lord.
F will not paragraph 12 is. 12.
Yes, yeah, absolutely, my lord.
Yes. Age.
600, my lord. Calcutta 600, referred to in that judgment.
Age of the compilation.
My lord, 24 Calcutta I relied on in Kai International. At paragraph, my lord, just 1 minute, my lord. At paragraph, yes, paragraph 6 of Kai International. Can you take, my lord, Kai International, paragraph 6? Dijendra versus Jogesh Chandra.
Only two are seen, arising out of one or two. But the tag is there, not item 31. 31 is same. The next item is same. You see, there are 7 or 8 matters in that, so I can give a memo, it can be disposed of same topic condition. No. I'll give not memo. Give the number, listed. Yes, sir.
Grateful, my lord. Grateful. But may I take your lordship's kind leave, my lord? Grateful.
Yes, call the next.
Much better.
My kindly see the last 25/6/2020. The will recollect on the.
Just 1 minute.
Kindly recollect on the last occasion, I submitted that.
They said 65 posts remained filled up.
The learned signature was perfectly right insofar as legal issues concerned. He is right. That's what I last time submitted. Now, only what remains is how to accommodate or to what extent the candidates can be accommodated. That was the only issue. Certain homework was required to be done. They have done some homework also. I will explain that homework, how it works out. After best possible, this one, the accommodation which can be done in this situation would be, last time I said 2. Now 3 can be accommodated at the most by qualifying it, taking into their all marks or merit or whatever it may be. That's how it works out. By notionally, by saying that there are some vacancies and by extending all these one notional vacancies also into account from the wait list, the names have been taken and their marks have been taken into consideration. Yes. Earlier, what we have done is while doing the homework, we said only 2. That is by taking into the recorded. Yes, recorded. Now we can extend by notionally extending the list into the vacancies and also wait list candidates marks also. By making that exercise, I think 3 candidates would fit in from unreserved category. Now, how the first table at the left side top, yes. From the bottom, 158. You have given the copy to the other side. You do not give the copy to the other side, sir. Yes, please. So from the bottom in the first table I'm writing unreserved 158, SC 43, 66 is the ST and 36, total 303 seats. Now actual offer of appointment which has been made was in non-ESM, that is ESM is the category. Ex-serviceman category. Non-ESM 84 was offered in UR. But the mistake what we have done is, as I pointed out, 74 was given in ESM itself. Entire that from horizontally it was given. That is the mistake. Therefore, 74 was given to horizontally under this one. Then SC nothing was given, ST nothing was given, OBC nothing was given. So finally, 158 were filled up. Actual offer of appointment was given. 43 SC, 63 and 36. This is the offer of appointment. Now kindly go to the third table at the left hand side. Yes, this is access shortfall offer to ESM, ex-serviceman. Yes, that is in this one UR should have been 39, but actually 74 was offered as per the previous table. So 35 was the excess. 35 excess candidates were given the appointment.
You have adjusted from SC and ST.
Yes, SC and ST nothing was given. It should have been parallel or equally distributed.
Absolutely.
Yes, it should have been done. That has not been done. So 35 extra has been appointed under the unreserved category. So kindly go to the next table number 4 on the right hand side. That is excess or shortfall offer to non-ESM, non-ex-serviceman. In unreserved category, it should have been 119. But offer was only to 84. Because ESM was included, wrongly done. So therefore, 35 could have been accommodated in the general merit itself. Yeah. In SC, 33 was given, should have been given on 33. But since no ESM was done, actually 43 has been given. 10 extra has been given in the SC. Similarly, in ST, 50 should have been given. But nothing was carved out from this one ESM category. So 66 was given. So 16 excess has been given under ST. Similarly, in OBC, 27 should have been given. Rather, they have given 36. So excess has been given in 3 categories, that is SC, ST, and OBC. Whereas in the unreserved category,
it is less.
It is less. Now, next table is table 5, joining against the offer of appointment, the vacancy table which we will get it.
Yes.
Yes.
Actually,
yes, actually, yeah. Joining against, this is joining. Yes. Post supposed to be filled up was 39 unreserved. actually joined 53 because ESM was given. Then under SC, ST and all it is as it is maintained, nothing further. It is for only ex-servicemen because nothing was given ex-servicemen for SC, ST or OBC. Now the next table on the right hand side, joining against offer of appointment. Joining against offer of a non-ESM. It is in non-ex-serviceman category. Here the first one is unreserved, post supposed to be filled up 119, actually joined at 61. It is non-ESM. So 58 minus deficiency. Then SC/ST again it is excess 33, is 33, 37, 50, 59, 27, 28. In all three categories, there has been excess. So SC, ST and OBC, therefore there can be no grievance at all. Excess already they have been made as against which could have been given under those categories.
Those could have been given less, but they have been given more.
More. That has been given. So now what remains is under the unreserved category. Now unreserved category now 58 could have been accommodated by notionally by going according to the merit. By such logic, now we are taking, now 84 was the actual non-ESM candidate at the second table we get 84, 58, that comes to 142. Now 142, the rank, the cutoff marks will be 39.5. In the third column we get at the bottom, right hand side.
Yes.
So by virtue of it, three candidates, there's Antariksh Jha, who secured 41, Manoj Ranjan Kuntia, 40.5, Suvendra Kumar Patrao, 39.5. That is exact cutoff mark. There may be about 5-6 candidates in this one, 39.5, but however less by giving this one. So three candidates by doing all the best exercise, they would have done it. Now, if you see the previous table, rest of the candidates and all secured far below the marks of 24, 25, 26, 30 and all. In yes, it was extended on the last occasion. I had
Three numbers of the prisoners failed.
yes, three candidates have even failed also.
That the repetition.
Even few have passed, but however their marks are much below. This is the position as it stands. This is by logically extending the entire list and by notionally taking all these are vacancies and carving out from the wait list also notionally what is their last mark, that is by taking it to the best possible situation.
One can
Yes,
think
yes,
about.
yes. And rest I leave to this one report. I leave to this one. Nothing more I can say.
See, this is what the petition is. We can't go and scrap the one of the things.
Your Lordship, may kindly see there this list 1 second. Your Lordship, may kindly see
they have indicated for the top lot, 119, 39, 158. 39 means now as per that reservation policy, 39 ESM has to get that from appointment lot. Other 35%, those who have been access to the general category, ESM persons who are appointed blood. Now, after this 119 and 39, 158, after 158, other so far as 35% are concerned, they will be spread over to all other categories, SC, ST and OBC blood.
But there has already been an access appointment in SC, ST and OBC category.
So
how can they be diverted now? Once they have admitted that they have committed a mistake. Now we cannot direct them to commit a further mistake or make it's a mistake. And now we will make it a blunder.
But if that is so, if they are saying blood, your lordship may kindly see the last order of the law. Your lordship specifically directed blood.
You said on the last order we were thinking about it. Yes, you say that there has been a large number of cases.
It's 65.
65 blood, your lordship specified.
So those can be done.
Yes,
they have come up with a figure that there is a 58 vacancies.
They have indicated 65 blood.
No. Where is a left out vacancy?
They have indicated in their counter affidavit blood. But
now they say that so far as 119 these are concerned, at best it can be said to be a 58 vacancy. Minus 58. That is what your stand is. Minus 58. Minus the sixth column.
Blood. 6. Yes. Minus
under UR.
Yes, blood.
So 119 is the post, out of which only the 61 persons they join. So there is still a vacancy to the extent of 58.
Yes,
in UR.
Yes, sir.
They say in SC, ST we have already exceeded. So we cannot create a further post for that.
But even after this blood, another 65 is there blood. They are saying that we have given that 58 blood.
Where is that?
Blood, your lordship kindly come to their affidavit blood.
In the affidavit, they must have said that 65 vacancies they did not join, there is a vacancy. But now, after all the exercise, they come to know that it is really a 58 vacancies. Then they say, if we have to fill up the 58 vacancies, then the cutoff marks will come and rank of 182nd. They have wrongly written as 182nd.
182.
It should be second.
Yes,
ND instead of TH.
Yes,
anyhow. So they say it will be 39.5 marks. So if they go by this, they say that only 3 they achieve more than 39.5 or 39.5.
Yeah.
So naturally they can be accommodated. And they will be accommodated. But why coming to this position? There are many candidates who have secured more marks than you. Then, if they are spared and all of you who secured lesser marks are accommodated, is it not an injustice to them?
Yes, sir.
So they will have to go by merit. They will appoint all those persons who are above you.
You are also the kindly appreciate, madam. So far as SCBC, OBC candidates are concerned, according to them, cutoff mark became 37.5 block. I have secured 30 marks block. Therefore, my humble submission was, if that ex-serviceman will spread over to other categories or the remaining vacancies will be filled up, Lord, in such situation, at least 12 persons will come to the from the OBC category, and I will be.
This is what it appears.
And my position.
This is what it appears that so far as the OBC, so far as ST, so far as SC is concerned, there is already an excess. They have committed a mistake of instead of 33, they have appointed 37. Exceeded. Instead of 50, they appointed 59. Instead of 27, they appointed 28 OBC. So they say that there is already an excess of 14. in these three categories.
Miller.
Then in that event, what to do now? Everybody has, then I will say, everybody has to be included as a party, otherwise they cannot be decided.
Miller, may I today they are giving this copy, Miller.
Oh,
Your
you want
Lordship,
what
Because
is
the
called-
final list is
yes,
there.
your Lordship may kindly give us 2-3 days time only. But I have some doubt because last occasion they have given that document last time. But I have also made some homework, and here it shows that but I have prepared that chart according to their initial note. But now they are giving another chart which is confusing. It is not tallying with the earlier chart. The earlier chart last occasion, your Lordship may kindly recollect, they have submitted this chart below. And now they are giving and indicating that they will go up to 82nd below. So far as my position is concerned, below, I am coming within that 125 below on merit below.
Then if the UR is considered,
my humble sum is,
if UR is considered, are you coming within 125? You will get it. No difficulty.
Okay.
Because they will go up to 182nd. So if you are above, get it. No difficulty.
Your Lordship may kindly give us one chance.
But if you are under the special
Yes,
category,
yes, yes.
then
Your Lordship give
They have
us
given the mail.
one more chance, my Lord.
if you want, then I can invite them to put on affidavits. They will admit their the mistake. There is no difficulty. And if everything is there, then I think the 3 persons who are eligible they should go home with a smile.
Lordship kindly say, Miller, they have already issued Miller list of candidates select against Miller all the quotas Millers, general AC and ST. Now Miller earlier they have stated Miller that 65 courts are lying vacant and we have filled up all the posts. Now Miller, yes, Miller, this is the counter affidavit.
They have not.
Because at different time Miller they have said
posts are there. We can definitely accommodate this 58%, giving them a notional benefit, whatever.
that is now Miller there.
So,
In this that Miller that is now say.
What is
Miller, let us give a chance Miller to compare
The
with the
difficulty
earlier
is
affidavit
that
Miller.
if we go by this chart, and this is according to the rules of the statute, it's permits that how much vacancies and how it's to be ascertained.
Yes, ma'am.
Then in that
Let them
there will
put
be
it in
a
affidavit so
14
that-
persons. There will be a 14 persons who will be out.
And they have
3 persons Miller, earlier they are telling about Miller 2 persons. In the last, you also kindly see the last Miller list they have given.
Only 2
They have
persons
given the
can
name
be
of Manas
accommodated.
Miller.
They say only 2 persons. can be
Earlier.
accommodated.
Now 1 person
Now
has
they
been
have
accounted
come
for.
up with a more, I would say with a great heart. They say we have included one more, now
Yes.
3 persons will be.
And at the same time, they are admitting that Miller in the selection process they have committed it.
No doubt. No doubt. That is what is a stand taken. That yes, it was a mistake which was committed. Now this thing has happened. Now what to do?
And they are saying that Miller.
What to do now?
Miller, if your Lordship will see that earlier counter affidavit. In that earlier counter affidavit also they have admitted that we have not given horizontal reservation.
Oh, that is what they.
Now they are saying that
they admit everything. Then they say that if it is considered in this fashion, then in that event, this will be the scenario.
What if pray?
They have already submitted that merit list before this honorable court. And let us to verify whether according this chart they have prepared in accordance with that merit list. And now they are saying 3 persons will get that. It will go.
Then, sir, if you speak on a merit list, then in that event, the difficulty is because there is a mistake there, and this is what it will come because ST, everything they have included.
No, we will not go with that part. We will not go with that part. Remaining 65 in respect of remaining 65.
You wanted whether this 182nd is correct or not, it will go down.
Yes. Then we'll see that much only. We are not pointing out that whether they have already committed the mistake.
And another thing, Lord, another prayer, Lord, let my Lord and Sinner be directed, Lord, to put it in affidavit.
You want?
Because
and then it will be easy for us as well.
So that everything, Lord, because it's a data, Lord, they are giving, and from this, Lord, 3 persons, Lord, they have given 2 persons. 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 3 persons, Lord, they It's a very confusing data, my lord.
We will verify. We cannot say
Result of the
exactly.
data, the past instance, my lord, it seems confusing. So let's see the detailed affidavit.
If you consider with an open mind, I do not think any confusion.
Let us give a chance to examine, my lord, with the earlier data they have given.
If you consider it with the lopsided mind that your client is going to suffer, then it's a confusion. It's a confusing one. What you will do?
No, every time they introduce
You are
one
officer of
document
the-
which is
you should know.
therefore we are in
What to
confusion.
do?
Since because earlier they have given different data, my lord. And in the affidavit, my lord, they have
Again,
admitted
we are
different things.
submitting another.
And every time, my lord, they are coming up with new things. My lord. That is why, my lord, we want to see, my lord, in comparison with the earlier
You
things.
just verify if you have any
Yes.
example talk. Is what is.
So let us give us a chance, my lord, to examine, my lord, with the other
Because that is from the basic list. If you want.
Yes, ma'am. You are also
But we are not going to expand a more SC, ST and the OBC.
No, we are not asking. The only
Just one
process.
sec. Can I suggest one thing? The records are here for their satisfaction. It's no problem for us. They can come and keep them, the officers for 5 minutes, let them verify by tomorrow, let them be satisfied. That's all. Because you do not want to shy away from anything.
Inspection of the record.
Let the records are there.
Whatever documents with us,
also-
we can also.
They are giving you the access.
Yes,
to
yes,
their records,
Yes, yes.
They are giving you access to their record.
In fact, if we go to that aspect, my lord, after committing a mistake, then now they are showing the record. Because your lordship may kindly see, so far as OBC is concerned, we must get 27% from the quota. They have given only 12%. We are not objecting that. We are not reopening the same, my lord.
They find that there is already an access.
No, my lord, we are not on that. The record they will show, itself will show that you have committed the mistake.
They are admitting you have. They have.
My lord, once they are admitting, they should accommodate us, my lord.
You will.
Last 10 years, last 11 years, we are
They have
fighting.
admitted they have committed a mistake.
Last 11 years, we are fighting for employment. And 65 posts are there, my lord. Last 11 years, we
And
are.
they are saying that, my lord, there is a, my lord, they have done the illegalities while this.
They are admitting that we have committed mistake, but they are not showing sympathy to give us this employment.
We also that any person who is above within that particular place, they must have joined somewhere else. They may not again join. You know,
Out of joint persons, some persons already left the job also.
if they after the joining they left.
That will be put for selection, my lord. And that I'm conscious that for selection. But many persons may have joined, but
Then you can't. Then it becomes a vacancy of that particular year.
due respect, my lord, your lordship, last occasion, your lordship suggested then. Since only 31 persons are here, 65 posts are there.
That is what we said. No?
But they are not agreeing that. Even my lord, after committing mistake, they are not agreeing.
Say that we can accommodate. Sorry, we can accommodate 3 out of this. Now we can't. I would say or force them to do something.
No, my lord, I'm not. My humble submission. One hand, they are admitting that we have committed mistake. Other hand, it's my lord's suggestion that to try to accommodate all those persons because 65 posts are there. They are not accepting the same law.
Was the suggestion that whether these 31?
Yes.
Just
yes.
So they have come up. It does not mean that the court.
Same law. I'm not saying that
They
you
have
lost.
come up and say that the 31 out of 31, we can accommodate at least 3 of them. And we have to go by a restaurant. We do not know. When the ASG is here, in the event out of this 54 or any person above the rank of 182nd, if they also refuse, if they are already there, then it will go down natural. That becomes. But it all depends. It all depends. What will happen? We can't anticipate that. Everybody may come and join.
Yes. You'll also kindly keep this matter next week. or 1 week after, my lord.
You
So-
go with the inspection, they have. With the inspection.
Yes, yes, my lord. Your
Because
lordship,
they
1 week
they
after,
have
your
got
lordship.
the over periods and accordingly they have given the chart.
My lord, may I pardon, my lord? So far as the applicant, Manoj Kumar Khutia is concerned, they have already.
I mean, you are happy, sir.
But they are not,
Go on.
they are not following the appointment, my lord. So, appointment order.
Convince them, they are standing in the way.
No, my lord. They have already argued.
My lord, we are standing on the way.
You.
They should give it appointment order.
My lord,
We
we are
are standing in.
No, they are not standing, my lord.
They are standing.
They have already
Say,
argued. So, you are
no,
not.
you should not be alone given. They should also be given along with you.
Your lordship kindly see the first order of this writ application. While
Fine,
we are admitting this writ application, your lordship has passed an order, my lord. Each and every appointment of this case, my lord, is subject to the result of the writ application. And in the appointment order also, my lord, is to the persons.
That is definitely subject to scrutiny, but you visualize the situation. Anyhow, you go through it.
Yes.
Pursuant to the order dated 25.
Okay. I'm actually Procedural from the beginning. I have developed part of my mind. There is no impediment.
What's the name of your
Antriksha.
Oh, they have already considered. Client should be happy.
My students there is no impediment in giving appointment.
That will be given. That means on your brother. On that side. Yes.
17.
A poor teacher filed for his arrear salary, which was denied by here my lord, a teacher paid for his arrear salary that has been denied by the honorable court, honorable single judge, without considering the rule, because the arrear was, it's a very small matter. The arrear was, my lord, from 1/1/2004 to 28/6/2010, that is in the on-train scale of pay. That was untrained because untrained. That was allowed by the State Education Tribunal, and the order was upheld by this Honorable Court Division Bench. That was also denied. And subsequently, I became trained on 14/3/2014. So thereafter, I say that this after I became a trained, so I must get my training skills. And that is also available in the rule itself, that on attaining the qualification, one is to get the training skill. That is Rule 16(2) of this rule. But without considering that aspect of that very particular rule, even the Honorable Court has dismissed my claim. That is before my court. But I am placing the facts because the poor litigant has been fighting out litigations. Only few dates I will state without opening the. I have given all the documents only. I'll just to summarize, I'll place it, my lord. I was appointed on 30/5/1992, having BSc qualification without having B.Ed degree, and that was permissible under the statute at the relevant time. My services were terminated on 7/9/2001. Against that, my lord, because it was an honorary institution, I filed an appeal before the appellate authority, that is the Regional Director of Education. That is the appellate forum created by the state. The appeal I have succeeded. In 2003, my appeal was allowed on 26/4/2003.
What it says?
It says that the termination is set aside. I am to be reinstated in service with all benefits. That was the order. I have given the order. I said, take my lord, read out. But I am just stating that I take my lords to each of documents. And in September 2003, the management allowed me to join back in the duty. And the institution became added. It became eligible to receive grant from the government from 1/1/2004. So proposal was submitted by the school authorities in favor of all the staff, remaining staff along with my name. But my claim was rejected on 21/9/2004 by the particular district education officer on the ground I was not having the training qualifications. Against that, all other staff were approved and they paid grant. So against that order, I had approached the State Education Tribunal under Section 24B of the Act. That is the provision. So the Land Tribunal allowed my appeal by judgment dated 3/2/2006. I filed in 2004 manner. That was allowed in 2006, directing that I should given the training scale from on train scale from 1/1/2004. But because this particular district education officer has disallowed my claim on 2004, this institution again disallowed me to work in the institution. But when I succeed, and the tribunal's order was not complied, and at the relevant time, there is no statute authorizing the tribunal to execute its own order. So therefore, the writ petition was filed before this honorable. This honorable court at division bench taken note of the fact that there is no provision in the statute directed that the order of the tribunal shall be complied with, and I shall be allowed to join back in duty. That was also not complied. I came in a contempt in 2007. The writ petition was disposed thereafter. Okay. Yes, first. My lord. In the contempt application was disposed of, directing that yes, within 4 months everything will be sorted out. That was also not complied. No section. I filed a miscellaneous application in that contempt that I have not been allowed. And there the honorable court has taken cognizance of the fact and directed personal appearance of the Secretary of the Department, School and Mass Education. Only at that juncture, my lord, that order was passed on 6/4/2009, and only after this order of personal appearance was directed on 5/7/2010, in a hurriedly, they have allowed me to join on 28 6/2010 and granted my salary from that particular date. But this tribunal directed me to get the salary from 1/1/2004 in the alternate scale of pay. And in fact, that was paid to me. In the meantime, my lord, on my own endeavor, and direction was also given in the by the tribunal that I should be given as a in-service candidate to undergo this training qualification. They didn't sponsor me, but I could have got it from the IGNOU man. Indira Gandhi Open University. I passed the B.Ed. So I acquired on 10/3/2014. So thereafter, management has also, the headmaster of the school, I was continuing, so they recommended that he must be given the training scale because I have obtained this. The rule 16(2) of the recruitment rule manual, which applies to me also, that says a teacher on completion of the training is to get the trade scale. When that was not paid, my lord, I came to this honorable court in a writ petition. This present writ petition, which was before this honorable court in 2014. And there, my lord, the order was passed. Without considering all these aspects, my lord, the honorable single judge held that because they have given it in 2010, you didn't challenge that, you cannot get the arrear salary. And so far this, arrear with regard to the alternate scale. And so far the trade scale, the court has straightaway denied that benefit without taking note of this. That is why I am before my lord. If my lord permit me, I will show all this document what I have stated, my lord, I have annexed it. But kindly give a glance to
the tribunal's earlier order of 2004?
Yes, that also I have given it plus 30.
Page
30, Annex 5. The ordering person is at 34. Shall I read, madam?
No, this is not 30.
30.
30.
30. Annex 5.
Yes.
JIPS 136 of 2004.
So what is the date? The date of the order is
3rd February 2006.
6.
Right.
So it says that
the case is
the appointment.
The case is allowed. Shall I read?
Yes, OP number 123 shall approve the appointment and shall give
the granted in alternate scale in a period of 3 months from the date of the order of rejection was challenged. That is 21/9/2004 order, wherein I am not given the benefit. So I am to get it along with my friends, my other colleagues in the institution from 1/1/2004. That was the alternate scale.
Correct.
This order was then by the next page 35. When that was not implemented, kindly turn to the honorable court. This honorable court's order in the earlier writ petition 863. I am just reading out what are the position then law. 25/9/2007. The petitioner, who is a trained graduate teacher,
implement the said award.
Yes, madam.
Correct.
Then, my lord, that was not complied. I filed the contempt. Contempt of place 39, madam. The first contempt, only contempt, madam. Case 39 of 4/8/2009. Learned government advocate seek for time, and it was directed that yes, it will comply within 4 months from that. Then, my lord, the contempt. This case 40, case 40. Here, my lord, the court has taken note of to initiate contempt proceeding against the school and mass education, Srimati Jagannath. Then, my lord, then, my lord, what is done? Annex 9, page 41. Approval was made 28 June 2010. they directed to approve. But this was on the thread of the contempt, they have stated so. But on the next date, an order was, peculiar order was passed. They say only I will get it from the date of rejoining. Though the tribunal has directed that one on 2004 mail. They say 2010 in the intermail, they didn't allow, the school authorities didn't allow me to join because the DO has rejected my claim for granting it. And now, only after the threat of this contempt matter, they have allowed me and they have granted my salary only from this 28/6/2010. They have taken a joining report from this person, though I am continuing, and the tribunal order has not been complied in this letter and spiel. I am to get it along with my friends from 1 on 2004. This is past part of my claim. From 28/6/2010, I have got it. Before that, I am to get it from, as per the tribunal's order, from 1 on 2004 to 27/6/2010. That is my claim, first claim. The second claim, my lord, I have got it. My lord, kindly turn to page 45, Annex 11. When I became trained, along with my certificate, it was recommended by the school to the inspector, the DO. On 29/4/2014, he has written like this. The headmaster of the school. Respectfully, I would like to invite your kind notice toward the subject cited above. Sri Ajit Kumar Misra, international teacher, CBZ of Jagannath Vidyapit, Khanua, is receiving on scale so and so from date 29/6.
Here from IGNOU,
IGNOU, my certificate number on date. Yes, I got it. I got the certificate.
Yes.
So now that is was recommended to the officer concerned. You give him the trained scale because now he became a trained person. That was the recommendation. When this recommendation was not acted upon, my lord, I filed this recommendation before this for a trained scale from 10/3/2000. Till date, my lord, the person is getting 4,500. A trained graduate teacher, his other friends are there getting about 60,000 salary. And 60,000 as per the government norm.
And you are getting?
I'm 4,500. This is
untrained.
That on-train scale, what was paid in 2010, till date, it has not got any change. This person, this is suffering. And so I should not say, well, the person could not marry also. Now he is 50 around, like that. He could not marry because of this plight of the person. I know the person, that is an emotional thing, I should not say, but this is a fact. He is only with the widow mother, she is living with 4,500. And the court has not taken note of what the rule says, Madam Policy. I'm just reading out the rule with regard to trained scale. I have kind of glance to that book, page 987, the recruitment rule. Order itself, I will fail in my duty, my lord, if you will not brought notice. The Honorable Court has gone to the counter affidavit, where in paragraph 15 of that particular counter, the authority concerned has filed before this Honorable Court, stating inter alia that he is not entitled. And the Honorable Court has come to a conclusion in this order that if you not challenge the para 15, then you will not get into. That is the finding.
Para 15, how can you challenge?
That is the finding of the court. And I am to, and the other finding is why you have not challenged the order of the tribunal, and why shall I challenge my tribunal or tribunal in my favor? That is the finding. And that para 15 also, another coordinate bench of this Honorable Court, I have the orders also. But if my lord cannot verify from the record, the Honorable Court in another coordinate bench has directed that how could you write this in affidavit? You will not obey the order of the tribunal. And he has appeared and said that his party ignored. And the Honorable, while finally deciding the issue, the court has not considered that as well. The reason I know, my lord, but I cannot speak.
Oh.
Lord, the tribunal's order that is staring at him, that he has never challenged, never questioned.
Why is it?
Because untrained scale.
Tribunal directed you to regularize his account.
Yes, that he will be, in fact.
You did not. Then he came before the court. Court passed the order for implementation.
Yes.
Ultimately, you implemented the order. So he was able from the date of the order of the tribunal.
Date of the order of the tribunal, he is getting the untrained scale. He claimed, my lord, your lordship.
It does not. You pay him an untrained scale from 2004 till the letter of recommendation was given after acquiring the training. So 2010, up to 2010, he does not want. He said that moment I acquired that training is the BA. Then from 2010 onwards, I'm entitled to a trained category.
Trained category from 2014, because he filed the writ petition after acquiring the training qualification.
Correct.
So the honorable court has directed that.
No,
your lordship may kindly see.
That he will be awarded a trained category.
Yes, my lord.
From
Your lordship.
2014.
Yes.
So
But that is the direction. Your lordship, the honorable court at page 130, if your lordship will find, has referred to the tribunal order, para 7.6. Now your lordship may kindly come to page 131, para 7.8.
Yes.
Not only the claim of the petitioner to get the benefit of trained scale pay, so recommended by the school by Annexure 3 series, since as found from the counter affidavit has been considered by the opposite party number 3 and the petitioner has been found ineligible to get the benefit unless and until such action of the opposite party number 3 is challenged by the petitioner.
What action? What action?
What it is
Why
that
it says, why it says not eligible? What action he will challenge? Tell me. Some order, something which he accused to it, did not. There is no order.
But the counter affidavit, your lordship will kindly see.
Will it go by ipse dixit of the counter affidavit? Parties have pleaded, both the parties have pleaded, then the court will have to consider on the parameter of both the sides. And the tribunal order does not really goes against him in that sense.
The tribunal order said that he will
Right.
That he will get the untrained scale.
Correct. No, he is not saying that I'm not.
That there is no
But
difficulty.
you have to pay as per what was the scale for the untrained.
Yes,
you not.
Untrained scale he has received, my lord.
But the periodical, the increment which is what is there that he has not received.
No, I am to get the trend scale as well as which is denied. Kindly see rule 16.2. Rule, madam, that is in the 1974 rules. What does the rule says, madam? A teacher is to get the trend scale on attaining the training qualification. That is the rule itself.
So that was in 2014.
Yes, madam. What?
You are entitled from
What my learned friend and as well as it was the argument before the honorable single judge was
talking about from
because the
2004 to 2010. What is your claim?
Yes, on trend scale, I never claimed.
So he's saying so.
From 14, I am to get trend scale. What the court
got it.
What my learned friend.
You received the untrained scale.
No, partly I get it. 10 to 14 I have got it. Till that I am getting on trend. 2004 to 2010 I have not got anything. 2010 to till date we are getting on trend in the lower rate, madam. From actually my entitlement to the training scale coming to 2014.
When the writ petition came to be disposed of by this court, and then the second contempt that comes, then they have regularized.
Yes. So
I understand.
Obliged.
But your case is that I am entitled from the date of the order of the tribunal.
On trend scale. On trend.
No.
Trend from 14 at this point. Because I got the training. That's what. And the court, as I am that I want to first speak out. What the court has understood, because I was doing the case The court says, because the tribunal says you will get on trade only, even if this rule is that you will not get anything. You will go on getting on trade. You have to challenge the tribunal order. Well, when the rule says, that was the period when I was on trade, I filed that case. And the rule says that I am getting 10 scale on attaining the training qualification. How could I challenge that order? That is the pity, my lord.
But you did not render services between 2004 to 2000.
No. 2004 immediately I had allowed, after the my condition was satisfied, I was allowed to join. After the 2004, my lord, that 21, yes, 21/9/2004. Yes.
When you were permitted to join.
Join on the 28/6/2010, man. That is the admitted fact.
What about 2004 to 2010?
I joined
After the order of the tribunal.
I was allowed to join for a few days. But from 21/9/2004, when my claim for approval was rejected, I was not allowed. That is when my absent period, my lord will take note of 21/9/2004 to 28/6/2010.
If you have not joined.
My lord. That is up to my lord to decide and this out of that. That is, I am not nothing. But the tribunal has said that I am entitled to the benefit from 1/1/2004.
And this order rejecting your regularization was challenged by you.
Yes, that was challenged in the tribunal. Tribunal has allowed. Tribunal directed no, he is to get the on-trade scale from 1/2004. That was not implemented by them. That is why all this contempt and all these things. How the person will suffer.
Then order of approval was passed. Approval he joined in 2010.
That is because of the contempt.
Understood, sir. But then question was asked for some other reason.
I understand.
For some other.
Rule 16 of the 1974, the Odisha Education Recruitment Condition of Service of Teachers and Members of the Staff of Aided Education Rule 1974, Rule 16. Probation and confirmation, Rule 2, 16(2). There is 2 provided in place of that. No teacher. I am reading out 16(2, my lord.
Read fast.
Pardon.
Read fast.
Sorry, I think I might not have got the. Yes, no. Sorry. No teacher who has not undergone the training prescribed to the post shall hold the post substantially, provided that an on-trained teacher having not less than 10 years of service shall undergo condensed in-service training provided by the government, and after successful completion of such training shall be eligible for confirmation and shall be entitled to draw salary of a trained teacher. Then provided further that a teacher attaining the age of 48 years shall be exempted from undergoing the training and shall be entitled to financial benefit of a trained teacher. I am now 56 years. In both the count, I am entitled to trained scale man. I am now 56. No, because I have trained. Had I not been trained even, I could have got it, man. I am 56. Yes, that is.
Government has sent you for service.
Yes, I confirm.
Government did not.
I have.
It is you.
They have been sent.
Did it.
Yes, ma'am.
So in that event, now you are entitled when you attain the age of 48, then you are entitled to a fifth.
Yes, that is also available. Why?
Yes. Yes. Does. Not good.
It's only for that period from the date he acquired the training qualification till date, and from 2014 onwards.
Now it is to some extent changed after looking at the second proviso to Rule 16.
But that was set at rest by the tribunal, my lord. That order was never challenged.
He was not 48
by then. But that issue, that he could have challenged the order of the tribunal then.
Have you not understood the thing which is playing in our mind? Please consider. He was allowed to join from 1992. He was continuing. Then thereafter there was a disruption. Then regularization was claimed. Regularization was rejected. He approached the tribunal. The tribunal says no, he is entitled.
Entitled for untrained.
Regularized as an untrained candidate.
Yes.
Yes, will not do. There is another bomb being hurled on you. Don't worry. Tribunal says regularize his appointment, treat him as an untrained teacher. Pay. He has no grievance because he is admittedly untrained at that point of time. And he was below the age of 48 at that time. You did not implement the order of the tribunal. Rather, you continued delaying the process. Ultimately, he approached the court by filing a writ petition, seeking an implementation of the order of the tribunal. The court disposed of directing you to do it, you did not.
Then contempt.
Then the contempt theories came. First, second, third, whatever. Anyhow, the first contempt came. The first contempt disposed of, you do it within certain time. Still you did not. Thanks that he approached the same court with the miscellaneous application. Then you say that I am regularizing.
Yes.
In 2010 or thereafter. And then you regularize this and treat him as an untrained candidate. No different. Thereafter, he acquired the qualifications which comes within the ambit of the trained candidate.
Yes.
Then he claimed that I am entitled to a trained category scale of thing. School also recommended it. Yes. But you rejected it. You said, no, you are not entitled. They approached the court. Now, if these facts are undisputed, then suppose first proviso strictly does not apply to him. But by this time, if he has crossed 48 years, treat him as an untrained candidate. Let us go to that extent, that he is still an untrained candidate. Then second proviso to Rule 16 says the moment a person crosses the age of 40, has not acquired the trained candidate's qualification, but he will be paid the salary of a trained candidate. Paying from 48. We go by your stand. That is, he is entitled to a trained candidate. Second is, why you have not paid him the salary, full salary of an untrained candidate?
Because his post was approved only in 2010.
He says that
and he
even
has
thereafter he is not paid the full.
Because of the contempt only they could pay.
They could pay.
Otherwise they were
Now, their entitlement, his entitlement, accrued from 2004. You could have challenged that order, you did not challenge. If for some judicial procedural lapses, he was unable to get the justice in time-bound manner, what to do? Two things that he knows. He has actually not rendered service from 2004 to 2012. Yes. Whether he should be paid the salary for the work which he never discharged. if such principle is accepted. But if the court finds that the deprivation was unreasonable, illegal, irrational, and with designed motive, will he not be compensated in any form?
That should have been the prayer made in the writ application, which has been adjudicated.
You are before the appellate court. Order 41, Rule 33 of the Code of Procedure permits, empowers the appellate court to do. Should I praise that?
I prayed for everything.
That's the power of the appellate court.
There, I prayed for. It is not adopted, I prayed. That was rejected.
The appellate court shall have power to pass a decree or make any order which ought to have been made or made, or and to pass or make such further or other decree or order as the case may require. And this power will be exercised by the court. Now you will take our defense. Answer is this. This power may be exercised by the court, notwithstanding that the appeal is as to a part only of a decree, and may be exercised in favor of all or any of the respondent of party, although the such respondent of parties may not have filed any appeal or objection, and may, where there have been a decrease in the cross-suit or a two cross-suit, be exercised in respect of all. So that power which is entitled, he can do it, even if he has not.
This is a letter patent
Which
appeal.
ought to have been passed.
Right. So far as CPC is concerned, there is no dispute about it.
And it applies to a writ proceedings.
But this is a letter patent appeal, my lord. Under
Then the appeal is regulated by with procedural law.
That I'll answer if your lordship will keep it to
No,
Monday. I'll answer it.
if a writ, the letter patent appeal is regulated and guided by which procedural law? There is no procedural law. Then it is the principles
of CPC.
What I have prayed, my lord, this
is what can't be honest. I will not be honest.
I'll answer my lord's query if your lordship will grant me
These are
some
the
time to
facts.
answer. Yes.
These are the
facts are
undisputed.
Facts are undisputed. Only I'll have to meet my lord's query.
Wow.
If your lordship will allow me till Monday, I'll come and answer that.
That is a ramification of my genetic defect. So interactive that it gives encouragement to enjoy adjournment.
poor person is
No,
suffering, my
no,
lord.
your lordship
But
have raised certain question of law. So I need to answer
law-
that, man.
This law is no application.
No, I
This
was
is
arguing for him.
This is not a case, in my case, because I have prayed for the areas. Only then. So I know my suffering of the person. That is my anxiety, otherwise nothing.
What the court has also asked.
Yes,
is that this is the
He is
fact
now
that what
50.
remained, then
He is
what he has to
56
say
years
on
old.
that?
Now can you consider?
What is to be done? And you can't deny that this rule 16(2) does not apply.
That I cannot. Rule is there.
So even if a stricto sensu, he is not entitled from a date when he acquired a BA degree, because he was already in service at that point. Yes. And the government has not approved that. Then the second proviso says that if he has crossed 48 years, then as an untrained candidate, he is inducted to a trained candidate skill. Yes.
That is the rule.
So treated as untrained, but given
Right.
trained categories.
when my appeal was allowed by the appellate authority, a direction was given to the government authorities to send me in-service training. That was in the order at Annex
You did
4.
not insist. You could have said that it is not, it is partially complied with.
Yes.
Why you did not raise this in the contempt?
But at the time of contempt, my lord, there was nothing has been. He was out of employment.
Oh, sir, then when you are so vociferous, so concerned about your right, then you should also be concerned about your. And first proviso simply say that by the government.
Yes.
Can't go anywhere else. Yes. Then what is the skill of an untrained candidate?
That is, my lord, now.
No, in 2000.
In 2000, that was, my lord, untrained scale was 1050. The basic pay. Trained scale was 1400. This was the difference.
And
that is
up to 2010.
2010, my lord, it is untrained scale. I cannot say, but trained scale goes up to 9300, the basic pay. In the corresponding 2006, 9300. That was the basic pay. Thereafter, it went up. Now in level 9, they are continuing.
One zero two five.
Yes.
That is.
There's no writ petition, not a writ appeal.
Writ petition has come along with this. That is.
So.
We have seen the age, we have not disclosed in the affidavit,
Yes.
also it 45 years on 30th May 2014.
Yes.
We add 3 years from there, so from June 2017. On that.
With the
Because
revision.
exact date of birth you have not disclosed.
If my lord will permit me 1 minute, I can go out and give the date of birth, exact date of birth.
Service due.
Sorry, I'll call that person
Service
and get a.
So that is why I'm putting.
I'm just giving my lord within 1 minute. And but
The case has a checkered history. The applicant is
Compensation, my lord, that is not.
I have not taken into account the expenditure which he has to make because of your litigation. I simply took into account that he says that untrained teacher salary in 2004 was 1,000 something. So that is what we.
You have challenged the tribunal's order, you know.
As compulsory. Yes. The petitioner is also entitled to a pay scale.
Preferred appeal, but it could not succeed. But a compensation provided, we have not involved any legal remedy and we have sat silent over the matter.
That though you have challenged it, but ultimately could not succeed. Because the remedies provided in the statute does not mean that a right which was fructified to a person should be kept in jeopardy. He should not lose. The Supreme Court, that's why I say, will not pass an order directing that particular salary to be paid because he did not render the service, but a compensation. That is deprivation. It is not because of that, deprivation.
Which is item 43, which your item 18, my lord. Item 18 to.
That's what I know.
Lord, with your lordship,
Your lordship, with your permission, your lordship, can I